예, 안녕하십니까. 정영 판사입니다.
Good afternoon. I am Judge Jung Hee-young. The very last session of the IIPCC will be the Moot Arbitration.
우선 지금 제가 사건의 개요를 먼저
I will first explain the case that we will deal with.
모의 중재 시나리오 PPT 좀 띄워주시기 바랍니다.
Please put on the slides. Thank you.
사건의 개요입니다.
So this is the case overview.
본 모의 중재 사건의 신청인 본안 사건
The
1990년부터
plaintiff
비장치를 제조 또는 판매해온 회사입니다.
is a company that has been manufacturing
본안 사건 피고는 2005년 신청인 회사의 연구원으로 입사하여 근무하다가
device B from the 1990s, and the
문제의 비장치
defendant is the previous researcher at this company who has worked since 2005. So
공정이라고 하겠습니다.
the component at issue here is component A, which is made during the earlier process, and
공정 이렇게 두 가지 공정.
device B is manufactured by also a later process where component A is equipped in device B. And regarding the essential component A,
약 10개 정도 종류의 기존
before this invention at issue, there were about a dozen or more than 10
발명자들 중 한
A components that were in the market.
B 장치에 장착되었던 핵심 부품인 기존
So
A
one of the inventors
새롭게 사용 가능한
have invented a new component A, which will be referred to as component AA from now on.
것입니다.
And this case is about that component AA and the manufacturing process of that component. So the researcher has worked at the company since 2005.
연구직원 3명이 더 있었습니다.
And in the research team, there were 3 more researchers.
당시 피신청인 회사의 기존
After joining the defendant's company,
연구를 대체할 만한 새로운
the research team has
현재 진행하는 중이었고
actually the research team originally at the company has been conducting research to replace component A for 3 years, and to identify the problem and resolve the problem,
리스트 작성을
they have partially completed a list that needed to be worked on.
피신청인은 그 연구팀과 함께
And
2011년
the plaintiff has joined that
제조 방법에
a
관한
team and completed the invention in 2011 with regards to component AA,
발명에 대해
and the research team
모두 신청인
has
양도했습니다.
transferred completely the right to acquire patents for that invention, and
사건 발명은
the invention
13년에
was
등록되었고
registered
2014년에는
under the Korean patent system, and was also registered. The patent was also registered in country D in 2014.
관계를 말씀드립니다.
Now, this is the relationship of use of the inventions. The defendant company, starting from 2012, produced a B device equipped with AA component in plants in Korea and country G. The B device that was produced were sold in Korea, country D, and also in country H, where its patent was not registered. And you can find the details in the reference book. And the defendant company
발명에 대한 실시권도 허락하였습니다.
has also entered licensing contracts
2015년에
in 2015 with company Queen.
비장치 관련
They
특허권이
entered a cross license
크로스 라이선스를 부여한
where they granted each other all patent rights and licenses with regards to device B, and Queen paid the defendant company 500 million won. And in 2016, with the Princess Company, the defendant actually granted the Princess Company a worldwide non-exclusive license for 10 patents that it held related to device B, and the defendant followed its regulations with regards to compensation and paid the plaintiff $10,750 as compensation. After leaving the company in 2020, the previous researcher, the inventor, filed a suit against the defendant company at the Seoul Central District Court in 2020, and they decided to forward this case to the panel judges of this conference, IPCC, in 2021. And at the issue for this case, whether the compensation paid to the plaintiff was fair, and how to calculate the profit that comes from practicing, self-practicing and licensing this invention, and calculation of the exclusivity contribution rate will be discussed. Now let me introduce the counsel for defendant and plaintiff. Please give them a round of applause.
그리고 모의 중재
And
판정부의 구성원인
now, this is the tribunal for the arbitration made of judges from Korea, Japan, and Germany, and they are going to join virtually from Germany and Japan.
예. 안녕하십니까? 저는 이번에
Hello, everyone. So, among the tribunal made of 3 arbitrators, I will be the chair arbitrator, Judge Lee Gi-hyung of the Patent Court, and we will refer to ourselves as arbitrators. So, based on the agreement on arbitration by the parties, this case was forwarded to our IIPCC panel, and I would like to introduce our arbitrators, Judge Herman Dreyfus from Germany, and also from the IP High Court of Japan, Honorable Judge Kumiko Katsumata. They were also panelists who shared their valuable insights in session 5. And as you can see from their bios, they are the best and top experts in the field. So they have very deep insights about this matter. Before we jump into the arbitration itself, as you are aware, arbitration requires high level of expertise and independence, just like the litigation court, but the terminology, procedures, makeup of the tribunal, and the element of private decisions can greatly affect this particular type of dispute resolution. The arbitration site was decided as Daejeon in South Korea. It will follow the Korean arbitration law and the Invention Promotion Act, and we will use Korean and English as the language. Well, we are seeing increasing cases about the patent, and this topic is very complex, but I'm sure if you follow closely, then you will be able to understand the details of the case. Invention, the decision of compensation on employees' invention needs to take into consideration many factors, and there are many still gaps in the jurisprudence with regards to this issue. But please keep in mind what you heard in session 5 to follow this case. And the award of today's panel are based on personal opinions of us arbitrators, and the issues are all hypothetical. hypothetical, which further needs to be addressed. So please take this as an academic discussion that will contribute to future progress in the area. And please look at page 358 in the reference book for the details of the arbitration procedures. So since we are going to deal with fair compensation for employee invention, we will first listen to arguments from both sides, and we will ask questions that we might have, and then each arbitrator will take time to deliver our opinions and deliver the final award. And the panel made of 3 arbitrators will follow the majority rule to reach the final award, and the award has the same force as the final decision of the court, and only a revocation suit can be filed against the award, which has to be filed within 3 months. Of course, this is a moot arbitration, so such procedures will not be followed through, but still, I just wanted to explain it. And so now I would like to introduce the counsel, but arbitrate. First, I will use both claimant and plaintiff as with regards to terminology. So first, attorney 전응준, second, attorney 인철근, and third, attorney 박성수 for the plaintiff side, and then now for the defendant side, attorney 김부한, attorney 구민승, attorney 권이선, and attorney 염호준. These are the counsel for the 2 sides, and our reference book also lists the name of all of the other professionals who have helped us prepare this arbitration. Now, let's jump into the case. The case number is 2021 Arbitration 1, and it was filed for the compensation for employment invention. We will now proceed with oral proceedings. I have to note one thing that is not in the reference book. The patent term ends in 2031, but the plaintiff only makes demand for compensation until 2020. And since there was no special mention in the written brief by the defendants, so we just decided to take that as a fact and rule on that. And the exchange rate, the $1 exchange rate is $1 to 1,167 won as of October 26th of 2021.
So this, just a pause. Please limit your presentation to 20 minutes. Go ahead. So this is our claim. The first, the defendant shall pay the plaintiff 5,407 million plus interest thereon at the rate of 12% per annum from the date, and also the cost of litigation shall be borne by the defendant, and the provisional execution application we'd like to withdraw it, and the B device was invented by the plaintiff in the course of working at the company, and the existing A component was going to be replaced by device B, and this invention is now registered as patent number 5 million. And R1, R2, and R3, there are multiple inventors. And also, the Korean patent takes priority in country D, but also registered as a patent in country D under the same invention name and the same inventor's name. This is the business circumstances. So before the plaintiff completed this component, the King company was the vendor, and so this company had to pay 5% of license to King before component B was completed. There were 5 companies who were able to produce device B. Goes to show how difficult it is to invent this device. And also, as this AA component is made, device G is made in Korea and other factories, and that's sold globally at estimated $1.1 billion. And AA component was used before component B was available. So the VSB's patent belongs to the defendant. And also, B production was reduced, and the overall production cost was reduced because of device B. And Princess has the 10 patent rights and the licenses, and the license cost, the royalties, about 10% of the revenue. And with the Queen B, with the AA and utility mode and all the licenses belong to Princess Company. And let me skip the details. You can refer to that. And the profit was divided among the 4 inventors, and defendant paid only $100,000 to the plaintiff as compensation. According to the governing law, the employee compensation for the invention should be fair. But the compensation was not fair because it does not reflect the feedback from the employee. So the compensation cannot be considered reasonable. And according to the defendant's policy on compensation, the inventor was not given any feedback about the compensation amount. But the compensation should be a fair amount. But there were performance compensation and disposal compensation, and they are all determined by the employer. So the employer's benefit is a key consideration. So if that benefit goes beyond a certain amount, then the compensation should also be larger. But that was not reflected in the compensation amount. And also, the compensation policy of the defendant covers only 7 years after the patent. But the patent term lasts about 20 years. So that is also unreasonable. And within a certain time period, if there was no application, then the inventor is deprived of the right to claim the compensation. That is also not reasonable. So, plaintiff has not received a fair amount of compensation given these circumstances. Let me explain about the compensation on page 10. So if you look at this, look at the profit and contribution, and each party's contribution for the joint invention. And also if you look at the profit, if you also look at the revenue, and we look at the hypothetical royalty. So this is how this is supposed to be calculated. On slide 13,
비장치 매출액이 나와 있는데요.
so this is about the device B.
미국의 특허권을
So basically, the patent is both in Korea and the country D. So based on these patents, revenues occurring in these countries are considered as benefit of this company. But as you can see at this table, there is a production in D and G.
특허권이 등록이 되지 않은 나라입니다.
Here, there's no patent registration. So in this case, what about the revenue of this case? We need to think about that, whether that should be recognized as a revenue basis for the compensation. So
지국에서 생산되고 H국에서
So it's produced in country G and sold in D, and we believe that these are closely related. So this country G revenue should also be basis for the compensation level. And for that, you can refer to the Supreme Court decision 2014 DA as written here.
판가가 있고 관련해서 특허법원
And also, if you look at the patent court decision, year 2020, now 1155 as well.
직무발명과 상담 인도
So employees' invention should be considered here when calculating the compensation based on the revenue in the non-patent registration country. So this revenue
매출액에 대해서
in country G, so in country H,
그리고 인과관계 문제로 돌아가는
what about causality?
법학에서는 어떤 일이 어떤 일이 발생한 것을 고려해서
If certain things didn't happen, we consider other things that happened. So that is the hypothesis. So here we need to think about the hypothesis where the inventor did not invent this device. So in the absence of this device, this company would have continued to pay 5% of a royalty rate to other company, other vendor, Queen. But
국내 생산과 지국 생산이
with this invention,
비용으로 있을 수밖에 없습니다. 만약에 이 사건 직무감이 없었다면
so without this invention, the company would have continued to pay that royalty to Queen.
그렇기 때문에 결국 지국 생산
So the production in G country and sales in H country would not have happened without this present invention. And second fact is
가 제한적 라이센스
the defendant had a limited license,
사건 직무감에 관련한
and also with this limited license, it still has control for the distribution and sales of this product.
제한적이지만 제한적
So even though the license is limited, still the defendant company has control. And also, if you look at, there are 5 competitors regarding this device in countries in D and other countries as well. But this patent, this invention patented in Korea, is also registered in country D as well. So because of the country D patent registration, these 2 companies are also within the scope of this patent. So it cannot go beyond the exclusive license. So given that, the device B, even though the revenue that occurred, even though the revenue occurred in the non-patent registered country, but that revenue should be considered for the basis of the compensation as well. And we also looked at the self-practice as well. Defendant has now 2 licenses.
피고의 사용자 이익으로 볼 수 있는
So we need to look at whether that,
독점권 실시로의 정의상
but based on the exclusivity,
다 사용자 이익으로 보는데 문제가 없습니다.
we can consider all the revenue as the benefit of the defendant company.
후공정에 이뤄낸
And also, much of these components, much of the processes that go into this device are later processed. So essentially,
장애라고 보입니다.
we believe that this device is subject to a licensing. And also for Queen Company, there's a license agreement as well, but that was a royalty-free license. But but that is on the condition of liability exemption for infringement. So we consider that as actually non-royalty-free license. And also we need to think about the contribution rate of the invention. And we calculated the contribution rate. We looked at the hypothetical royalty rate. But given that we can use the hypothetical royalty rate, we did not feel the need to calculate specifically each inventor's contribution rate. Slide 19. So we do not believe the contribution ratio need to be considered specifically separately, but the contribution ratio of the invention at issue is 100%, because the other 9 patents in the later stage, they are all replaceable. And also, their contribution is only 2 compared to alternative technologies. And also, the production cost of device D decreased from 20 to 15% of the sales. And the hypothetical royalty rate is another issue here. And we need to see if the license has been granted in the past, but there was no such license granted in the past. Then we need to look at the impact from this invention on the market status, the market share, sales growth, etc. On page 21, but in this case, in present case, there were 2 royalties that could be considered. First, the defendant paid a royalty to company King. In this case, the defendant paid a license fee to company King in country D, but that was kind of replaceable. So when the defendant gives a license to a similar license to others, the same rate can be applicable. And case 2 is that the defendant has received a royalty from Princess Company. So if we move on to the next page. So regarding Princess Company, the royalty rate was quite high, but that was for 10 patents. So we needed, so it was very difficult to kind of separate royalty rate for each patent. But since we are talking about 10 patents as a whole, and also we do not believe that 9 patents out of that 10 patents are that valuable. So we cannot equally divide the given royalty rate among 10 patents. So as such, we believe that 5% is it's the right amount for the hypothetical royalty rate. And also, do we need to consider the average royalty rate of the same technical field, which is 30%? So when there were precedents regarding royalty rate, we could refer that as a reference, but that is not the case here. So we do not believe that we can strictly abide by the 3% average. And also the contribution rate of exclusivity as well. So defendants had excess profit thanks to this invention. So that needs to be recognized as well. But there's no objective data to support that. So given that, The contribution rate of exclusivity can be determined by looking at what has been the impact on this company's market share thanks to this device. Given that, after this invention was made and the patent was registered and the product was marketed and sold, the market share of this company grew to 55%. So we believe that the contribution rate of exclusivity of this invention is approximately 45%. And regarding the contribution rate of exclusivity, and when this invention is practiced by others, we believe that the contribution rate of exclusivity should be 100%. But we also need to see if this practice by others has any negative impact on the defendant. But in our view, the other parties practicing this invention is at a very negligible amount. So for self-practice, we do not see the exclusive profit. And inventor's contribution. So we believe that the inventor's contribution is 70%. The inventor already has a high academic degree of PhD, but this company did not have enough basic research until our plaintiff came to work. So we believe that the inventor's contribution is 70%. And last, there are 4 co-inventors to this invention. So we are going to claim 25% given that. So our conclusion is that the defendant is obligated to pay the plaintiff $5.4 billion. And excluding the already provided $10,750 in the U.S., there's the remaining outstanding amount that needs to be paid to the plaintiff. With this, I'd like to conclude my presentation. Thank you.
No, thank you, Plaintiff's Counsel. Now it's the defendant side's turn for your oral proceeding. So we will start our response. Well, we have to look at the fairness of the regulations surrounding the compensation. So in order to look at whether it was reasonable compensation, we have to look at whether the procedure surrounding stipulation of the standards and whether provision was fair and whether the circumstances surrounding hearing employee opinions was fair. So first, in the process of stipulation of compensation standards, defendant engaged in negotiations and heard opinions from employees. And second, the plaintiff was included in the employees who were able to access the published compensation regulations. And third, with regards to employee opinion hearing, there was the internal process where if deliberation was necessary for determining the standards, the employees can join, and even after the compensation was set, the plaintiff had the choice to raise objections. So, given the 3 circumstances, the compensation was provided following the reasonable procedures that is required under the Promotion Invention Act. So there is no additional compensation that is necessary.
피고의 매출로 인한
And also with regards to
해서
profits from the defendant's sale,
부분은 피고의 매출액 관련 주장과
well, the argument
그리고
with regards to sales
기여도에 대한 원고
and
정당성
the invention's contribution
먼저
rate. I'll look at how the plaintiff's arguments are unreasonable. So first, I'll look at the unreasonableness of their argument with regards to sales.
특허 비등록국
The sales in the countries where patent is not registered,
국가에서 일어난 매출
the sales in such countries,
매출액에 산입하여야 하는
should that be included in the whole of the profits? Well, jumping to the conclusion, the defendant thinks that
동일 유사한 장치의 판매를
identical and similar product sales
판매할 수 있는
being excluded
법적 지위가 없기 때문에
under an exclusive status that is not valid in the countries where the patent is not registered, so sales from such countries should not be included in calculating the compensation. Going into the detail, the defendant thinks that,
근거로 두 가지 판결을 제시를 하고 있습니다.
well, we have opinions with regards to the Supreme Court decisions cited by the plaintiff from 2017 and another from 2021.
특허법 판결에 대한 주장을
With regards to the Supreme Court decision,
기본적으로 특허 비등록국
states
매출액을
that
하여야 한다고
the sales from country where patent is not registered should be included because
해서 실시가 있었다라는
it can be deemed that the patent was practiced in
근거
Korea. That is the biggest ground for such decision. But
등록한 것은 아니라고
I don't think that just simply the fact that such practice could have taken place should be the standard, because when it comes to invention,
생각자가 얻을 이익이
what it matters is what the employer is gaining.
판매로 이어지지 않았다면
If
이러한
it
이익이
did not
없다고 보아야
lead to actual sales, then we should think that there wasn't actual profit.
이 특허원 판결에 의하면
Based on this Supreme Court decision, it says that while it should be included in calculation, but it should be considered as a factor to reduce the contribution rate
국정권 기여를 낮추는 데
or
고려한다면
of the exclusivity.
특허 비등록국에서의
If so, then sales in country where patent is not registered, then contribution of exclusivity in that case would be almost zero.
원고 측에서 들었던 판결을
Because
보면은
if we look at the ruling
이렇게 판시를 하고 있습니다.
from 2017, it shows that
직무 발명을 실시할 수 없게
if
함으로써
banning competitors from practicing the
직무 발명을 실시할 수 없게 함으로써
patented employee's invention, if that led to increase in sales, that is when this is applicable. So in country H,
되어 있지 않기 때문에
the patent is not registered,
특허권의 기회
so
경쟁 회사로 하여금
the patent right over the employee's invention did not prohibit competitors from practicing such an invention. Therefore, contribution rate of exclusivity in such case. So even if we do include sales from country H, due to the factor of contribution of exclusivity, it will be reduced to zero in the end, anyways. And in the country where the patent was registered, sales in such countries should be considered. If we look at sales in country H that was produced in country G, so even the country where production took place, the patent was not registered. So the Supreme Court case is not applicable to this case. And I will explain about the unreasonableness of the argument about the contribution of the invention. Plaintiff said that the contribution ratio is 100%. But out of the whole production process, this is only one component, and the process technology thereof. There are 10 inventions used for device B. And with regards to other 9 patents, the plaintiff's argument totally just neglects the other 9. Even if we factor in all other factors, the argument that the invention's contribution ratio is 100% would have no grounds. Now, I will talk about the unreasonableness of the plaintiff's argument on the hypothetical royalty rate. So the King's patent can replace this invention. So the plaintiff argues that the royalty rate for the King's company component, which was 5%, should be applied here, but royalty rate should take into consideration the actual circumstances of when the royalty rate was decided. At that time, there were only 5 countries that can manufacture this, and they did not engage in any licensing agreements further. So the defendant company had a less powerful position in the negotiation vis-a-vis the King company. But after this invention, now there are 6 companies, so the royalty rate should be reduced now. And at that time, they thought that the royalty rate should increase because the sales they thought would increase, but the trends shifted starting from 2017. And with regards to the licensing agreement and the royalty rate from Princess Company, actually the royalty rate was for the total package of 10 patents, so that royalty rate is not directly applicable for this case. So it is the defendant's position that the average rate in the industry should be applied for the royalty rate of this component. And the precedents here show that the average royalty rate is usually what is used to determine the royalty rate. So the average rate of 3% should be used as the hypothetical royalty rate for this component. And it is impossible to actually set it as higher than 2% if we consider all of the circumstances. And out of all of the components used for device B, this is just one component. So the contracts were with the Princess Company where royalty rate was set at 12% for 10 components, it can't be directly applied because although we don't divide equally among the 10 patents, still it should be considered. And the defendant made investment and efforts for the sales of device B, and after 2017, the sales for device B has been decreasing, and the validity period will come to an end soon for component A, which will increase the number of alternative technology. And if we look at the Korean cases, the hypothetical rate usually is somewhere between 2 to 3%. There was one case where there was 5% royalty rate, but this was a pharmaceutical invention, and 5% was the average rate of that industry, so that's why this was cited. So in our case, 3% should be applied, but given all of the other circumstances, 2% of royalty rate should be the maximum reasonable hypothetical royalty rate. Also, with regards to arguments, plaintiff's argument regarding exclusive rights contribution ratio, well, the market share at the time was taken into consideration, but it's a rather arbitrary argument because 2017 was when market share was at its peak. And even if we follow their logic, only 35% was increased. And from 2017 and now, the sales has greatly decreased starting from 2017. And from this, we can tell that this component's inventions contribution to the sales of device B was not significant. The actually defendants' foothold in the market and its technical prowess have greatly contributed to the sales also. So the actual exclusivity contribution rate is not as high as plaintiff is arguing, and we should also take into consideration that with King and Princess Company, the defendant did enter licensing agreements, so exclusivity was undermined. So the royalty rate and exclusivity rate contribution are all included in calculation of the compensation. But since the defendant's exclusive status is undermined due to licensing agreements, this should be factored in. And lastly, although we think that sales from countries where patent is not registered, although we think that it should be excluded, it would still be greatly reduced due to the exclusivity rate. And with regards to defendants' royalty profits out of licensing agreement with third parties, the employer's profit generated from self-practice and royalty income from licensing agreements, in such cases, the employer's profit is from a royalty-free, non-exclusive license, which is not an exclusive profit. So when we calculate the employer's profit, the profit from self-practice, if that is considered, then separately, if we also factor in royalty income from Princess and King, then it would lead to an exaggeration of the employer's profit. It was mentioned, but plaintiff is almost arguing that the other 9 patents in the later process are not valuable, but in fact, the later process related 9 patents have the effect of reducing production cost by 2% compared to all of the other comparable technologies. Therefore, through the licensing agreement among the invention that was licensed out to Princess, we should consider the value of the 9 patents. So even if the $100,000 of royalty income from Princess is considered as employer's profit, among the royalty income from Princess, the income thereof will only be $100,000. And about the licensing agreement with Queen Company, well, this is actually the contract. So among the parties, if a written agreement was made, if the language is clear and there are no special circumstances, that content should be respected. That is what the Supreme Court of Korea holds. The licensing agreement between defendant and Queen, it is royalty-free, and the $500 million that was paid to the defendant is for the exemption of any infringement of patent. It is very clearly written. So the plaintiff's interpretation goes against what is written in the contract and is therefore unjust, and the defendant's income coming out of this contract is not a royalty, but it is merely for the exemption of any patent infringement liability. And it is a cross-licensing agreement. Through the cross-licensing agreement, it is difficult to say that the plaintiff only gained from the contract. The defendant was also able to practice the patent of Queen. And between the defendant and the Queen, the subject of licensing includes all future patents that the two might retain until 2025. So the plaintiff argument is unreasonable in that it does not take this fact into consideration.
부공정 관련 9개의 특허권이
The 9 patents are valuable. The 9 patents that is related to the later process, but I already explained, so I will skip this part.
장시 생산을 위해서 퀸사의
For the production of device B,
퀸사가
we don't need Queen's authorization,
문제를 제기하지 않았다는 사정만으로
but just because Queen did not file for such infringement, it cannot prove that any patent of company Queen was not used in this process. So the plaintiff's argument does not have grounds. None of the plaintiff's arguments have grounds, and even if the 500 million won that was paid from Queen, even if that is with regards to the patent, but the amount of profit would be a lot lower than what the plaintiff is arguing.
다음은 발명자 공헌도에 관해서 설명드리겠습니다.
Now, the contribution ratio of the inventor is the entirety minus the employer's contribution, which would include any support or investment from the employer. So looking at we have to look at all the process of completing the invention and registering the patent right for the invention. The employer spent huge amount of investment for the research and development of the invention. And if we look at the process of registering the patent, if the employer had to spend a lot of money and time and effort for registration, then the contribution rate would consider to be very high. And depending on the manner in which the employer practices the patent, the actual profit would greatly vary. To look at the contribution ratio of the employer in this case, it is almost $0.9 million. And even before the plaintiff joined the research team at the defendant company, relevant research has been going on for 3 years. So the defendant company already had know-how and technology with regards to this invention, and a lot of the employer's resources were put in to this invention. Also, the defendant had to spend a lot of resources to engage a professional firm to get this patent registered. And the defendant had to move through the commercialization procedures and actually manufacture this invention. The practicing ability and the licensing ability was what achieved all the licensing agreements with the other companies. If we take into consideration these facts, the contribution rate of employer should be 95%. And with regards to the contribution rate among the joint inventors, it will be 1/4. This would be the end of our argument. Thank you.
So we've listened to both sides' presentations. So for each point, each party made a very compelling case. So this is not easy to come to a conclusion. But now we will take questions from the arbitrators. So arbitrators, do you have any questions for either party?
Oh, I don't have any questions at the moment. Thank you.
예, 알겠습니다.
Thank you. Honorable Katsumata.
Yes, I have two questions. The first question is, I'd like to ask both defendant and plaintiff. The question is, with regard to the opinion hearing to the employee, did the defendant hear the plaintiff's opinion about the amount of compensation? If the answer is yes, what did the defendant, when and what did the defendant hear? And the plaintiff's opinion was, what was the plaintiff's opinion?
일단 답을 하시겠습니까?
예, 시나리오에는
Per the scenario, so the defendant does not take so there is no indication that the defendant takes opinions, listen to the opinions of the plaintiff. But even if that is the case, regarding if the need arises, there is a possibility that the employee can speak up, and also even after the compensation was fixed, there was actually grace period where the plaintiff was able to submit their opinion. And second question?
예. 가츠마타 우리
Honorable Katsumata, can you pose your second question?
Yes, and my second question is, I'd like to ask the defendant. The second question is with regard to the licensing agreement with Queen Company. I wonder why the defendant doesn't pay money to Queen Company. Could you explain the reason and what the parties took into consideration when they agreed the conditions and the amount of money?
네, 답변 드리도록 하겠습니다. 답변에 앞서서 가능하다면 우리 그 PPT 17면을
Before answering the question, please, can you put up slide 17 for the organizers? This is a request for the organizers. Yes, I'll start answering while in the meanwhile.
퀸사의 라이센스 계약
The licensing with the Queen Company
감사합니다. 다음과 같습니다. 여기
is, as you
보시면
can see on the slide,
상황에서 실시료는
So,
무상인 크로스
in
라이센스
3, it's a royalty-free cross-licensing, and for the parties, it is for the exemption of patent infringement for both sides. So in return for exemption of such liability, 500 million won was paid. That is very clearly stated in this licensing agreement. Therefore, so this is for the exemption of any liability for patent infringement, and how this specific amount was set comprehensively takes into account various factors, so I can't explain everything in detail here. Thank you.
하셨고요. 제가 원고 측에다 한 가지만
Yes, so I have also one question.
지금 쟁점인데요.
So regarding contribution, so the employer, they also did all the professional service investment, for example, assessment of the invention value and patent registration. Given that, what is the employer's contribution in your view? Once the invention is complete, then we believe that that kind of contribution by the employer needs to be recognized, of course, but the same principle can be applied in a negative way. For example, the patent registration is done only in Korea and in D country, but the patent registration was not done in other countries that are at issue here. So we also need to think about employers' responsibility in that regard as well. So if there's no further question here, we will close the Q&A session from the arbitrators. So the plaintiff's final closing remarks. Final closing remarks. So for the inventor needs to receive a fair compensation, because that will benefit the society overall, because that will encourage further inventions. So that is why employees' invention needs to be fairly compensated according to the law. And so as long as the employer enjoys a benefit from that invention, and And as long as there is a nexus between the employee's contribution to the invention, and irrespective of whether that invention is registered as a patent in the selling country or not, that all should be considered as the contribution of the inventor. Then how fairly share the profit among the employer and the inventor? That is an important issue here. And I believe that the honorable arbitrators will come to reasonable judgment on that. But we also need to think about the positive impact on the employer's market share thanks to this invention, and we believe that the plaintiffs is entitled to a much fair share of the profit than what he currently received.
예,
And now for the defendant side,
피고회사가 원고에게 지급한 보상금이 정당하다는 건가요?
the compensation's reasonableness will be reviewed. The standards for the compensation, opinion hearing process, and the stipulation provision of compensation all followed the fair procedures. Therefore, the fair, reasonable compensation was paid, and there is no additional amount to be paid. And with regards to how it will affect the society, the R&D costs was very heavy for the part of the defendant, and even before the plaintiff joined the company, the research has been already ongoing.
국가 입사하기 전부터
And even before,
피고회사의
yes, the plaintiff joined the company already used a lot of material and human resources. And even after the invention, a lot of effort was necessary to acquire the patent. The practicing ability and the licensing ability of the defendant greatly contributed to the sales, so the defendant's contribution ratio is pretty high in this case. And the sales in countries where patent is not registered should not be included in calculating the compensation, since there is no exclusivity. And even if it is included, the contribution of exclusivity is almost 0%. And the invention's contribution ratio is low because it is one of the 10 patents that are used for the device B, so it should be much lowered. And about calculating the compensation, the patents with relation to component A, there were only 5 companies who retained relevant rights at the time, and there were no further licensing agreements made. But since then, the circumstances greatly changed because there is one more company that can manufacture. So it is no longer a highly monopolized market among just 5 companies anymore. And at the time, it was expected that the sales would rise, but from 2017, the sales took a downturn. Therefore, rather than the patent, the sales, it was largely due to the market significance of the defendant, rather than simply this patent. Just one last comment. The plaintiff has mentioned in their final argument the purpose of the employee invention system. If there is a specific need, then a reasonable compensation should be made for the invention, but at the same time, it should not be overestimated. When it comes to practicing and licensing of patent, I would like to emphasize this one point. When we look at profits from self-practice by the defendant, including the royalty rate from Princess and Queen, adding that to the profit, this would bloat the profits for the employer. Thank you.
맞으셨습니까?
Thank you all.
상방이
So yes, both parties are very fierce in their presentation. Excuse me. the defendant actually took more time, so can we add one more point to our final comment? So here, but the revenue in the country where the patent is not registered, should it be considered as a basis for the compensation? That is a key issue here. So basically, if there is relevance can be established, then that should be considered. That is the Supreme Court ruling in Korea. But of course, as the defendant mentioned, so the product, when the product is partially produced in Korea, where the patent is registered, or if it is produced in other countries and then brought back to Korea. So actually, that was the case for that Supreme Court ruling. So that was slight difference from this case. But still, even if there's a no patent registration in other markets, it is clear that this employee's invention made a contribution to the sales that occurred in the country where the no patent was registered. So that should be why that revenue should be considered as well. Thank you very much. So now our panel will have discussion. Our arbitrators are going to have a discussion. But our two arbitrators, so now we are going to listen to our arbitrators' opinions, and given each country's rules and regulations about how these issues are resolved. First of all, I want to thank Honorable Dreyfus for participating. So, Honorable Dreyfus, could you give us your opinion on this matter?
Yes, thank you. First of all, I want to say that it is an honor and a privilege to be invited to participate in this Moot Arbitration Board. And I'm very thankful, and it was kind of adventure to work on this case, and it was also great fun to work on it. My compliments to the brilliant interpreters. Thank you very much. I understood what you said. It was very good. And I'm very impressed by the pleadings, by the high quality of the pleadings of both the counsel of both sides. Now let me make some remarks on the case as I see it in my German view. I do my best to understand the Korean law, but you may understand that it's not easy for me. As regards the relevance of the defendant's guidelines, I understood Article 15, subsection 2, to mean that compensation under a guideline is to be deemed fair and thus materially correct if compliance with certain procedural requirements sufficiently ensures that the compensation is not too low. I held that the defendant's submission that it was not necessary to hear the plaintiff before the compensation was fixed, but it was sufficient that he could object afterwards, means that the plaintiff was not heard in advance at all. And I just heard the confirmation of this as an answer to the question of my colleague from Japan. That, however, seems to me indispensable. I think the employee has to be heard in advance. Now I have learned that Article 15 allows for substantive control. So the question is whether the compensation according to the guidelines is fair. I hold that it is too low. Second point, there's a discussion of whether the sales in country H are to be taken into account. Here I share the defendant's view. It is also the case under German law that sales in patent-free foreign countries are not to be taken into account for the assessment of the compensation. This is plausible to me. Although the employer implements the invention, he has waived patent protection in country H. However, the compensation for an employer's invention is paid just for making a contribution to a patent-protected position of the employer. Under German law, the employer is in principle only entitled but not obliged to register the invention for protection abroad. As a compensation, he must then allow the employee to register the property right there. Next point, contribution of the invention to the overall product. From the German point of view, this would not be an independent point. A separate determination of the contribution of the invention to the value of the overall product, in this case, the fact that the invention concerns only component AA and not the entire end product B, this is not necessary, as this is taken into account when determining the hypothetical royalty rate. Next point, reasonable hypothetical royalty rate. I tend to follow the plaintiff here. Not only does the defendant save the royalty rate for King, but also has the benefit of significant cost reduction. I would also consider here the high royalty rate that Princess pays, 12%. Next point, contribution rate of exclusivity. Now, this is something very hard for me because we don't know that in German law. This difference between the Korean law and the German law is based on the fact that an employer who does not claim a service invention has no right to use the invention under German law. So he has no non-exclusive license as in Korea. It is therefore very difficult to me to put a value on this. Sorry. Revenues from exploitation of the invention through licensing. As regards this point, the plaintiff submits that this amount should be assessed in full, and the defendant argues that only 1/10 should be assessed. I do not think either side is right. According to the case overview, it is true that one does not need the 9 patents of the defendant for the later process to produce B. However, these 9 patents bring a cost advantage of 2%. Therefore, I would tend to argue that of the 12% that Princess pays, 2% goes to those 9 patents and 10% goes to the plaintiff's invention. In my view, that also fits with other facts in the case overview. According to this, the defendant paid 5% royalties to King. She can save that money now. In addition, the plaintiff's inventions brings a cost advantage in the production of B by 5%, so 5% and 5%, that makes 10%. For this reason, I would tend to consider 5/6 of the royalty income in favor of the plaintiff, 83%. The same would apply to the compensatory payment of 500 million won by Queen. As regards the plaintiff's share, I find it particularly difficult to argue under Korean law, as I do not know the criteria by which quotas are determined there. I lack experience, of course. If I had to apply the German guidelines, this would probably result in the following. For the setting of the object, I would probably assess 2 points. As to the solution of the object, I would probably also assess 2 points. And as to the plaintiff's duties and position, one would probably place him in the second or the third group, meaning 2 or 3 points. According to the table that you find in number 36 of the German guidelines, one would probably assess the share factor of the plaintiff with 10 to 13%. The plaintiff share thereof being a quarter, the result would be a factor of 2.5% to 3.25%. So if I had to resolve the case with a view to German law, I would probably end up with a proposal to pay the plaintiff a sum in the order of 350,000 to 400,000 US dollar. If I would try to resolve the case under Korean law, I would gladly agree with my distinguished colleague Lee. Thank you.
예, 대단히 감사합니다. 진짜 좋은 의견 주셨습니다.
Thank you so much for your valuable opinion. Now, Honorable Judge Katsumata, could you share your opinion, please?
Thank you. This is Kumiko Katsumata, Judge of IP High Court of Japan, and I thank you for inviting me as an arbitrator in this session. And I'm sorry for a little technical problem for a while. Anyway, I'd like to explain my opinion. With regard to the existence of the defendant's obligation to provide the plaintiff with the compensation for the employee's invention, I think the defendant has the obligation. I understand that the defendant did not hear the inventor's opinion satisfactorily. So, in the light of Article 15, Section 2 of Old Invention Promotion Act of Korea, the compensation shall not be deemed fair. For your information, to talk about the situation in Japan, the Patent Act of Japan has a similar provision of Article 15, Section 2 of Old Invention Promotion Act of Korea. It is thought to be unreasonable to determine the amount of the compensation in accordance with the employment regulation, providing how to calculate the amount of compensation, which corresponds to the defendant guideline in this case. If the amount of the compensation calculated in accordance with the employment regulation is excessively small compared to the amount of the compensation calculated based on the employer's profit gained by making use of the employee's invention patent, even when the employment regulation was legitimately enacted. In this case, the amount of compensation determined in accordance with the defendant guideline is excessively small compared to the amount of compensation calculated based on the employer's profit, as I explained later. Thus, the defendant has the obligation to provide the plaintiff with the compensation for the employee's invention in accordance with Japanese practice. Next, I'm going to explain the calculation, the amount of the compensation. In this case, the amount of the compensation should be calculated based on the employer's profit from utilizing the employee's invention patent. The employer's profit includes both the profit obtained by selling the patent invention products and by licensing the patent. First, with regard to the profit from the sales practice, the compensation should be paid based on the defendant's profit gained by sale or manufacture in the country where the patent registered. In this case, sales of device B manufactured in country G and sold in country H should be excluded because the profit from the sales in country H cannot be deemed as the profit obtained by executing the patent. Therefore, total amount sales of device B from the patent at issue is 943 million US dollars. Next, with regard to contribution to the employee's invention, the contribution ratio of the invention is to be determined taking into consideration the technical importance of the invention. In this case, the patent at issue is much more important than the other 9 patents in the light of the following facts. One, the patent at issue relates to the earlier process, which requires 2/3 of the production cost, and the rest 9 patents relate to the later process. 2, the share of device B has increased greatly after the invention. 3, the defendant was able to enter into the cross-licensing agreement with Clean Company after the patent registration. 4, the plaintiff is awarded as the inventor of the invention at issue by the Prime Minister of Korea in 2014. I assume that the contribution of the invention at issue 70% by taking into consideration with these facts I mentioned. Next, with regard to the hypothetical royalty rate. In this case, the defendant agreed with Princess Company granting non-exclusive license for patent relevant to device B. And in this contract, Princess Company should pay 12% of the sales as a royalty for defendant's 10 parent, including the invention at issue. The defendant should have to pay 5% of sales as a royalty to King Company for a parent to manufacture component A before the invention. In addition to the conditions of these contracts, taking into consideration the average royalty rate 3% in that industry, and of the importance of the invention among 10 parents related to device B I mentioned before, I assume that 5% of hypothetical royalty rate is reasonable to apply to this case. Next, with regard to the contribution ratio of exclusivity, I think 30% is appropriate, taking into consideration the fact that the share in Korea of device B has increased from 10% to 55% or 45% after the invention. And the defendant effort for mass manufacture and mass sales has been a significant contribution to the increase in the market share in Korea. And defendant's 10 parents, including the parent at issue, makes it possible for 5 companies who retains parents related to the component A to form a high parent barrier. So moving on the profit from license agreement. With regard to the license agreement with Princess Company, there is no typical way to estimate the profit related to the parent at issue. However, from my point of view, the profit can be calculated with the contribution ratio of the parent. In this case, the contribution ratio of the parent at issue among 10 patents related to device B is 70%. So the profit is calculated as $70,000. Then, with regard to the agreement with Queen Company, 500 million won can be deemed as a license fee practically for the 10 patents related to device B, even if I consider the answer of the defendant in the Q&A session. In this case, I will use the contribution ratio of the patent again and calculate the profit as 350 million won. Next issue is inventor's contribution ratio, or the level of the employer's contribution. As to the level of the employer's contribution in this case is, I think 95% is appropriate, because the defendant's contribution for the profit is huge, taking into consideration the process of the invention, and the defendant had invested a huge amount of money to research and commercialization. Therefore, the inventor's contribution ratio is 5%. And the plaintiff's contribution ratio to joint invention is 25%. It is undisputed. At last, according to my calculation using all factors I mentioned, the compensation for self-practice shall be $123,768.75, and compensation for the license is $4,623.93, and plaintiff was already paid $10,750. So as a conclusion, my opinion is that the defendant shall pay the plaintiff $170,642.68. That's all.
예, 잘 들었습니다. 이제 이상으로 독일
Thank you very much. So we listened to the really valuable opinions from our arbitrators from Germany and Japan. Each country has different traditions and practices as to how to calculate the compensation. So thank you so much for your valuable input. And I believe that both amounts are very fair and reasonable. And I think that will give us a great reference point for us here in Korea. And we need to now submit the proposal for both parties. So can we see the slide, please, on the screen?
예,
Yes,
띄워주시죠. 예.
Yes.
저희가
Thank
이제
you.
계산을 해본
So we had some calculation. So whether this is fair compensation or not. So as both arbitrators mentioned, that the given compensation was not fair. So more amount needs to be given to the inventor. If I can go over each component of the compensation.
자의 이익이죠. 그 자기 실수로
So the self-practice profit.
들으신 바처럼
As you heard,
그래서
so the majority here agrees
100만 불
that we need to exclude the $215 million. But other than that, this amount is going to be is calculated as the revenue of this employer. So, but once again, this is the issue that we need to keep talking about in the future for actual practice. As both parties mentioned, as both parties quoted some precedents in Korea, so there's still many issues to discuss. And those precedents are different cases, of course, so they have different circumstances to consider. So this is still an ongoing issue in Korea. And next, contribution by the employees, invention, 80%. So we come to 80%. There are other patents that made a contribution. So this 80% is what we came to. And hypothetical royalty rate, 5%. We arrive at 5%. We believe 5% is reasonable. And the contribution rate of exclusivity, in the case of Germany, they have very specific formula to calculate this. So it might be different from what we used here to arrive at 30%, but we arrived at 30% here. So total profits, as you can see here, $11.316 million. So inventor's contribution ratio is the next item. So this was really hotly debated here. In the case of Japan, we heard 5%. So 95% seems to be given to the employer in Japan. But in the case of Germany, as we listen to Honorable Dijkvans, there's a concept of the employee's stake. So the concept setting is first stage, task is set first, and then there are other steps to calculate, for example, the object and the solution and the contribution as such. So each element is evaluated, and then each element is given a score. So we saw that very specific formula that is used in Germany. So given both countries' formula, we came to 10%. But again, so 10% probably might appear to be higher for the Japanese standard. So I believe some scholars criticize this. So in Japan, we understand that sometimes even 5% is considered high. But here we all, so this we also need to think about civil law as well. So it really boils down to how honest and how accurate the employer's revenue numbers are. So that's a really key point here. So in conclusion, we come to 10%. And ratio to the joint invention, 25%. The plaintiff's contribution ratio to the joint invention, we arrive at 25%. The compensation is here, $282,900. And licensing agreement compensation, that was most difficult part for us to calculate actually. So when you self-practice the patent and also give the license to third party, so what should be considered as exclusivity, the profit from exclusivity? How should we determine that? So I think that boils down to the license. That's what many academia discuss. So for example, some people say that there's no exclusivity in that case, but others have different opinion. And here, so this is again hotly debated topic, but we believe that exclusivity exists in this case. Then we need to think about the contribution rate of the exclusivity for self-practice. But again, exclusivity here is a kind of two sides of the same coin, exclusivity and self-practice. So that's how we consider this element. And we looked at the Princess company's royalty, so 60%. So we decided to recognize 60% of what the princess's share. So we believe that that's kind of a good basis, and based on that, we looked at the inventor's contribution and also joint invention contribution. And we, for Queen, we came up with 500 million in Korean won. This was also difficult to calculate because this is a cross-licensing case. So it means that even future royalty is included here in this cross-licensing arrangement. And also, we are talking about 10 patents in one product. And also, except this one patent, there are other replaceable substitute technologies as well. And also, we also need to think about the substitution as well, and also future royalty amount as well. So it was very difficult to calculate this, and we talked about this a lot because in the case of cross-licensing, the license that we give and the license that we receive, we also need to calculate it all together, and we need to get the net amount to see if there's a profit or if there's a benefit. So that was very complicated, and so we determined that there is a less exclusivity profit from Princess. So that is how we arrived at this amount. And we looked at, so we came at this amount, $285,350 for the total compensation. But then again, $10,750 is already paid. So if you deduct that, then the remaining amount to be paid to the plaintiff is $290,000. So this is the proposal that we want to put forward. So once again, thank you very much for our arbitrators, Honorable Daifas, particularly because we understand that this is a very late time in your time zone. So thank you very much for staying with us. And also, we thank you for your really high quality opinions as well. So Honorable Daifas and Honorable Kasmata, we we hope that we can keep exchange ideas. We hope to exchange. We hope to continue to learn from the continental laws as well. With this, we'd like to conclude this mock arbitration. Employers' invention is really a big research topic at the court, patent court in Korea, actually. So once again, thank you so much, Honorable Daifas and Honorable Katsumata, for being with us till the end and for your very valuable input from your countries. Thank you all very much.